Hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you will enjoy this legal education content, and today will be the day I earn that subscription. For today's story, we're going to try to do a bit of a breakdown on the recent U.S. Supreme Court decision regarding abortion. This is the case of Dobbs versus Jackson's Women's Health Organization, which overruled Roe versus Wade and Casey versus Planned Parenthood. It's two major seminal decisions in the United States regarding abortion, and this decision, by its own express terms, overrules them and becomes the new decision at the highest levels on abortion. And we're going to discuss this in a legal posture. So for those of you who are relatively new to the channel, as so many of you are, and I do appreciate all your subscriptions, I just wanted to make a couple of things clear at the start. First of all, I'm going to provide a legal analysis. I'm going to try to provide what I think the law says and doesn't say, and analyze the decision from positions of legal posture and legal reasoning. Some of it is good, and some of it is a little bit weak, in my opinion, and that's a legal opinion. I'm not here to provide moral questions. So if your questions are about what's good or bad, about abortion or not, or what consequences may ensue from abortion being illegal or whatever, those are fine considerations. They're just not my considerations. My considerations are as to what the law requires. And that moral considerations as to the input or potential consequences of this are not my domain, and those are best left to somebody else. I'm just going to try to provide what the law says and doesn't say, and we'll go from there. The other thing that I think is sort of worthy of mention about my own reasoning, as I sort of implied just now, is that I think more procedurally rather than in terms of consequences. I tend to think about things in terms of process. I don't tend to look at the end result that will emerge. I tend to look more at the process of how we got there, on a belief that if we follow the process, whatever emerges is the correct result. And if we made a mistake, it must be a mistake in the process, not the result. So again, as to what consequences may or may not ensue from this decision are not my domain. Not to point out the fine point that they're all speculative anyway, and I don't think necessarily that anyone who's predicting anything will be come to pass, because we just don't know what the future holds in terms of it, in terms of consequences. And if we did, I wouldn't factor them in anyway, because those are not part of what I consider to be legal reasoning. Legal consequentialism is not reasoning, at least in my view. That being said, let's go ahead and discuss this case and what it does and does not say regarding the future, and points that are weak or not weak. So I guess the bottom line of all this is that this returns the question of abortion to the states. It is now up to each individual state to define what abortion is or is not for its state level government, and each of the several states will be able to define it as they please. So that's the bottom line, but let's go through the reasoning as to how we got there. This is an opinion delivered by Justice Alito of the United States Supreme Court, who writes the following. For the first 150 years after the adoption of the Constitution, each state was permitted to address this issue in accordance with the views of its citizens. Then in 1973, this court decided Roe versus Wade. Even though the Constitution makes no mention of abortion, the court held that it confers a broad right to obtain one. It did not claim that American law or the common law had ever recognized such a right, and its survey of history ranged from constitutionally irrelevant to the plainly incorrect. After cataloging a wealth of other information having no bearing on the meaning of the Constitution, the opinion concluded with a numbered set of rules, much like those that might be found in a statute enacted by a legislature. So one of the things he points out right away is that abortion, of course, is nowhere to be found within the text of the Constitution. And even assuming that you could get a right to an abortion somehow out of its text, or implicit otherwise, Roe itself sets forth a enumerated framework that's a little bit difficult to find in the Constitution. It's like, where exactly is the framework coming from? Otherwise, it's just kind of made up. And that's not the things that courts do, right? They don't create things out of whole cloth. So it is a little bit suspect for those reasons. At the time of Roe, 30 states still prohibited abortion at all stages. In the years prior to the decision, about a third of states had liberalized their laws, but Roe abruptly ended the political process. It imposed the same highly restrictive regime on the entire nation, and effectively struck down the abortion laws of every single state. Eventually, in Planned Parenthood versus Casey, the court revisited Roe, but the members of the court split 3 ways. 2 justices expressed no desire to change Roe in any way. 4 others wanted to overrule the decision in its entirety, and 3 remaining justices, who jointly signed what would become the controlling opinion, took a third position. Their opinion did not endorse Roe's reasoning, and even hinted that one or more of its authors might have reservations about whether the Constitution protects a right to an abortion. But the opinion concluded that stare decisis, which calls for prior decisions to be followed in most instances, requires adherence to what it called Roe's central holding, that states may not constitutionally protect fetal life before viability, even if that holding was wrong. Anything less, the opinion claimed, would undermine respect for this court and the rule of law. Paradoxically, the judgment in Casey did a fair amount of overruling. Several important decisions were overruled in total, and Roe itself was overruled in part. Casey threw out Roe's trimester scheme because Roe originally set up a first trimester, second trimester, third trimester framework. First trimester, abortion would be allowed. Second trimester, abortion could be regulated. And third trimester, abortion could be forbidden. Again, where this 3 trimester framework came from in a sort of a constitutional sense is kind of suspect. Where is this coming from? So it overthrew this trimester scheme and substituted a new rule, which also has uncertain origin, because where is it coming from, under which states were forbidden from adopting any regulation that imposed an undue burden on a woman's right to have an abortion. The decision provided no clear guidance about the difference between a due and undue burden. That is for damn sure, because what exactly is an undue burden? That was a problem. But 3 justices who authored the controlling opinion called the contending sides of the national controversy to end their national division by treating the court's decision as the final settlement of the question on the constitutional right of abortion. No, not so much. As has become increasingly apparent in the intervening years, Casey, of course, did not achieve that goal. So, Casey itself is a mess of a decision because it has no majority opinion. It has only a plurality opinion. And it comes up with this fractured, unclear mess. The central holding of which you have to actually cobble together votes to get, is that you come up with this undue burden framework. And then they say, well, we want this to be the last word on the controversy. No, not really. No, not so much. So, let's carry on. So they hold no bar here by just saying they say finally, we hold that Roe and Casey must be overruled. So at least they're being clear. The Constitution makes no reference to abortion, certainly in its own text it doesn't, and no such right is implicitly protected by any constitutional provision, including the one in which defenders of Roe and Casey provide. Okay, and there's a super chat. So let me go ahead and read that. Jay Wolfenstein says, I've decided to... I'm not reading that. That provision has been held to guarantee some rights that are not mentioned in the Constitution, but any such right must be deeply rooted in the nation's history and tradition and implicit in the concept of or liberty. The right to abortion does not fall within this category. Until the later part of the 20th century, such a right was entirely unknown in American law. Indeed, when the 14th Amendment was adopted, 3/4 of the states made abortion a crime at all stages of pregnancy. The abortion right is also critically different from any other right the court has held to fall within the 14th Amendment protection of liberty. Roe defenders characterized the abortion right as similar to rights recognizing in past decisions involving matters such as intimate relationships, contraception, and marriage, but abortion is fundamentally different, as both Roe and Casey acknowledged, because it destroys what those decisions call fetal life, and what the law before us now calls an unborn human being. Now, one of the points of criticism I will have for this decision is it just assumes as a given the fact that this is different because of this reason. But why? It doesn't really quite establish it. It just takes it as a given. It says that Roe and Casey and Dobbs are different because it destroys fetal life or destroys an unborn human being. Maybe that's true, but why is that factor dispositive or relevant? In a legal sense, the case never quite establishes. It just says it is for some reason. So there's a weakness there. Why is that factor legally relevant or not? All right, let's read some more. Constitutional analysis must always begin with the language of the instrument, and always a good place to start, which offers a fixed standard for ascertaining what our founding documents mean. This is true. I think you have to start with the text, and I think originalism is correct, because things mean what they mean at the time they're written or said. I'm literally saying words right now. These words have particular meanings. They have particular meanings as they exist right now. These meanings may or may not necessarily be readily apparent, although hopefully it is, because I hope to speak with clarity. But if there is any ambiguity, even though there might be ambiguity, they still had meaning at the time I uttered them, right? And that meaning, whatever I'm saying right now, the meaning behind these words can't change in the future, because I'm saying the words now. So they have the meaning they have now. They can't have the meaning they would have later. That doesn't make any sense, because I'm uttering the words now. So as the English language might change in the future or not, or as perceptions of people might change in the future or not, as people might view this video in a month or 100 years or 1,000 years, whatever people might be able to divine or not from my meaning doesn't actually undermine my actual meaning or change my meaning. I can only mean what I mean now. If I write a letter today, it means what I mean now. It doesn't mean what someone reads it to be in 1,000 years. It can only mean what it meant now, right? Its meaning is fixed. The words are fixed. The meaning is fixed. Whatever confusion might exist. So yes, the Constitution is fixed in time. Just like any legislation, Congress might write a legislation today. It has a meaning today. That meaning stays consistent no matter what happens in the future. It can only mean what it means now. And so we must start with that principle. Otherwise, it is unmoored from any sort of reality. Roe, however, was remarkably loose in its treatment of the text. Yeah. It held the abortion right, which is not mentioned in the Constitution, is part of a right of privacy, which of course is also not mentioned. And as to that privacy right, Roe observed, it had been found to spring from no fewer than 5 different rights. The 1st, 4th, 5th, 9th, and 14th Amendments. This is not a promising place to start. It's like, yeah, we're going to try to cobble together a right to privacy as emanating from 5 different rights. And from that itself, we're going to further emanate a right to an abortion. This is quite tenuous. This is also why I think that people who are saying absurd things like, this means that the Supreme Court might say, I don't know, we no longer have freedom of speech or something, is absurd. Because it's right there in the First Amendment. The whole problem with Roe is it doesn't come from anywhere. It's not in there. It's not in the text. It's not really coming from anything. The court's discussion left open at least 3 ways in which some combination of these provisions could protect the right. One possibility was the right was founded in the 9th Amendment's reservation rights to the people, which would mean that it was always a right from the very start of the country. Incidentally, if that were true, because the 9th Amendment was written in 1791. So it would mean that it was true as of 1791. Okay. Another was it was rooted in the 1st, 4th, or 5th Amendment, or some combination thereof, which would also mean it was true in 1791. And this right had been incorporated in the Due Process Clause of the 14th Amendment. Okay, so it was also true in 1791. All right. And a third path was the 1st, 4th, and 5th Amendments played no role, and the right was simply a component of liberty protected by the 14th Amendment. So under this interpretation, the 1st, 4th, 5th, and 9th Amendments or anything else are irrelevant. When we wrote the 14th Amendment, when we wrote the word liberty, one of the things we meant was abortion in 1860s. Yeah, this seems a little bit, yeah. Roe expressed the feeling the 14th Amendment was provision that did the work, but the message seemed to be the abortion right could be found somewhere in the Constitution, and specifying the exact location was not of paramount importance. And there's a footnote I thought we would read, because the court's actual words were as follows in the underlying opinion. The right of privacy, whether it founded in the 14th Amendment concept of personal liberty and restrictions upon state action, or we feel it is, or as the district court determined it, in the 9th Amendment reservation of rights to people, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. Okay, yeah, this is a little bit tenuous. Birdie says, hi, Kurt. Can you please explain all the concerns that are coming up surrounding the desegregation based on Dobbs and how the two issues are related? It's a bit confusing to me. We'll try to get there in some parts as we get to some of the more analysis on some of the other things, but the idea at least is that we would want to attack for other reasons. I don't think attacks on desegregation work because desegregation is based off of equal protection, and the idea of race-based classification being suspect is derivative of 13th, 14th, and 15th Amendments. So I don't think you have the same problem. So I don't really quite see it, but fair enough. And Nimrath said, row your case up to the Supreme. Merrily, your constitutional rights but a dream. R.I.P. Roe versus Wade. Thank you, Kurt. And Rest of Dodge says, I love listening to your videos at work. Excellent. I'm glad you do. Okay. Neither Roe nor Casey saw fit to invoke this theory, and squarely foreclosed by our precedents, which established the state's regulation of abortion is not a sex-based classification, and thus not subject to heightened scrutiny that applies to classifications. So a regulation of abortion is not sex-based regulation, because just because it applies to one sex doesn't mean it's regulating because of that sex. And so that is what the Supreme Court's precedents hold. The regulation of medical procedure that only one sex can undergo does not trigger heightened constitutional scrutiny unless the regulation is a mere pretext designed to effect an invidious discrimination against members of one sex or the other. As the court has stated, the goal of preventing abortion does not constitute invidious discriminatory animus against women. We're not doing it because we hate women. That would be animus. We're not doing it out of hatred of women. The motivation is to protect the unborn. At least that's the idea. The underlying theory on which this argument rests, the 14th Amendment's Due Process Clause, provides substantive as well as procedural protection for liberty, has long been controversial. It sure has. Justice Thomas, wasting no time, again attacks this concept. And we'll get to that a little bit more when we get to Justice Thomas's concurrence. But the entire idea of substantive due process is a little bit weird. It doesn't really make sense. It's something the Supreme Court invented to fix a problem that they themselves created in these cases called the slaughterhouse cases, where they basically nuked the Privileges or Immunities Clause of Section 1 of the 14th Amendment. And then, rather than unnuking it, which would have been the most rational thing to do, they instead created this entire idea of substantive due process. And substance and process don't really make sense in the same sentence. Substance, process, these are kind of different things. And then the Supreme Court said they're the same thing. So yes, the entire concept of substantive due process has been controversial, is controversial. It's a little bit geeky because to some extent, it's not clear that it really matters that much, except in some sort of legal purism. Because if you undid all of substantive due process, you'd probably wind up mostly, if not completely, exactly where you are now, just through other means. So to some degree, what's the point? But yeah, it's controversial. Kurt, how do you square originalism with dealing with issues that did not exist at the time of the founding, such as electronic communications? Oh, that's easy. It's not a problem. The Constitution protects freedom of press. Freedom of press means the literal physical printing press. People misunderstand freedom of press to refer to like the organization of the press, like newspapers or something, members of the press, the press as an entity. This is an incorrect interpretation. Freedom of the press belongs to everybody. It can't mean the New York Times. Freedom of the press does not mean the New York Times. Freedom of the press does not mean the Washington Post. You have freedom of press individually. So it can't mean that. It has to mean you. So how does that make any sense? Because freedom of press talks about methodologies of spreading message. Freedom of speech is what you say. Freedom of press is the methodology or mechanisms by which you say it. Freedom of press refers literally to the actual physical device of the actual physical printing press. The literal freedom to use the actual physical device. That's what it means. And by extension and by analogy to its more modern equivalents. A thing like Facebook, or a thing even like a text message, is just a printing press. It's just a particularly modern one. That's digital instead of analog. It's just a printing press, nothing more. It's the same printing press it ever was, just a little modernized with a different kind of keyboard and a different kind of mechanism of working, and instead of printing on paper, it sends a message over a wire and displays on a screen instead of a piece of paper. It's just the printing press it always was. That's how you deal with it. That's how you deal with it. It's the same thing it ever was. Technology does not change the underlying aspect of what it is. It's just the printing press, nothing more. And so you have the freedom to use the printing press just as you ever did. I hope this answers your question. The first consists of rights guaranteed by the first 8 amendments. Those rights originally applied only to the first federal government. They sure did. The Constitution's Bill of Rights only applied to the federal government at the start. But this court has held the Due Process Clause of the 14th Amendment incorporates the great majority of those rights and thus makes them equally applicable to states. Absolutely. The second category, which is the one in question here, comprises a select list of fundamental rights that are not mentioned anywhere in the Constitution. In deciding whether a right falls into either of these categories, the court has long asked whether a right is deeply rooted in our history and tradition, and whether it's essential to our nation's scheme of order and liberty. Justice Ginsburg's opinion for the courts in Timms is a recent example. In concluding, the Eighth Amendment protections against excess fines is fundamental to our scheme of order and liberty and deeply rooted in this nation's history and tradition. Her opinion traces the right back to Magna Carta, Blackstone's commentaries, and 35 of 37 states in effective ratification of the 14th Amendment. Timms dealt with excess fines, incidentally, and whether or not that was applicable to the states, because that was one of the last provisions to be incorporated against the states, which happened, like 3 years ago? It was so recent. But yeah, and how do you determine whether or not it's a fundamental right? Well, this is a good way to do it. Is it fundamental to our order, scheme of liberty? Well, here are some reasons it is. Here's some commentary from Magna Carta, Blackstone, and 35 of 37 state constitutions treated it as fundamental, so that's a pretty good clue. Okay, great. Timms and McDonald's concern the right whether the 14th Amendment protects the rights that are expressly set out in the Bill of Rights, and would be anomalous if similar historical support were not required when a putative right is not mentioned anywhere in the Constitution. Thus, Glucksberg, which held that the Due Process Clause does not confer a right to assisted suicide, the court surveyed more than 700 years of Anglo-American common law, and it made clear that a fundamental right must be objectively deeply rooted in this nation's history and tradition, which not so much. No. Suicide historically was illegal, and I believe still is in some parts of the United States, but I'm not an expert on such things. Historical inquiries of this nature are essential whenever we're asked to recognize a new component of liberty, protected by the Due Process Clause, because the term liberty alone provides little guidance. Liberty is a capacious term. As Lincoln once said, we all declare for liberty, but in using the same word, we do not all mean the same thing. Yeah, what is liberty is a little bit tenuous, so not the greatest choice for reasoning. Which is also, incidentally, why the substantive due process idea doesn't really make sense, because substantive due process tries to squeeze in the entire Bill of Rights into the word liberty in the 14th Amendment. That's what it does. It says, oh, the entire Bill of Rights is liberty. All right, that's okay. This is, it makes more sense to say it's part of the privileges and immunities, because that's like, that's okay, more what it is. But, once again, we knew the first section of the 14th Amendment, so we had to come about it in a different way, and yeah. On occasion, when the court ignored the appropriate limits imposed by respect for teachings of history, it has fallen into a freewheeling judicial policymaking that characterized discredited decisions such as Lochner. This court must not fall prey to such an unprincipled approach. Instead, guided by history and tradition, the map of essential components of our nation's concept of world liberty, we must ask where the 14th Amendment means by the term liberty. When we engage in that inquiry in the present case, the clear answer is the 14th Amendment does not protect the right to an abortion. Never has. No historical analog. It doesn't make any logical sense, right? Modern firearms are just modernized versions of old firearms. The old firearms are protected, and they're the same thing basically that they ever were. They work basically the same way. They're just more modernized versions of what was protected. Same with freedom of press. It's the same thing it ever was. It's just slightly more modernized, slightly different, but it basically is the same fundamental device, same fundamental thing it was 250 years ago. It's really fundamentally no different than it ever was. Yes, it works a little bit differently, right? Well, it's the same thing. Until the later part of the 20th century, there was no support in American law for a constitutional right to obtain an abortion. No state constitutional provision had recognized such a right. Until a few years before Roe was handed down, no state or federal court had recognized such a right. This is pretty good evidence that there isn't such a right. Again, when you're looking at other rights, you look to see what else is existing. When you look to something like Tim's and you're trying to decide, hey, this excess fine clause, is that applicable against the states? Well, the fact that 35 state constitutions say it is kind of a clue. You know? Kind of a clue that it does. Nimrith, you're not going to get me to sing tonight because it's too serious a topic. We're trying to get through this in a serious, logical way. So we're just going to do this logically, but I appreciate your super chat. All right. I don't want to be unduly cavalier in my discussions. And although law review articles are not reticent about advocating new rights, the earliest articles proposing a constitutional right to abortion come to our attention was published only a few years before Roe. Law reviews are like the professional publications of the lawyers. And yeah, they're the ones that do all the analysis and thinking. That's how the lawyers do their thinking, how the academy does the thinking, is through law reviews principally. And you can't really find any support for it at all, except, before a few years before Roe. So it's a little kind of weak. Not only was there no such support for a constitutional right until shortly before Roe, but abortion had long been a crime in every single state. At common law, abortion was criminal, at least in some stages of pregnancy, and was regarded as unlawful and could have very serious consequences at all stages. And that doesn't quite make sense, by the way. It's criminal at some stages, but unlawful at all stages? It's like, that doesn't quite make sense, but okay. I mean, there are aspects of the decision that are a little bit, iffy, and that's one of them. Here's another one that I still think is a little bit iffy. This whole idea of quickening and the way they treat it historically is a little bit iffy in terms of the analysis. So let's discuss what the Supreme Court said. We begin with the common law under which abortion was a crime, at least until after quickening. The first felt movement of a fetus in the womb, which usually occurs between the 16th and 18th week of pregnancy. Okay? The eminent common law authorities, Blackstone, Koch, Hale, and the like, all described abortion after quickening as criminal. Now, when it comes to abortion after quickening, I think the Supreme Court has it about right. Yes, after quickening, it was treated as a fully living person, and maybe not so much beforehand. So the Supreme Court is right on the after quickening aspect, after the first movement in the womb. The question is, are they right historically about the movement or before that point? That's where I think they're a little weak. Sir Edward Cook's 17th century treatise likewise asserted abortion of a quick child was murder, and the child be born alive, and a great misprision if the child died in the body. Again, as to a quick child, All right. England's cases dating all the way back to the 13th century corroborate the treatise's statements that abortion was a crime. After quickening, I think you're there. Before quickening, I'm not so sure. Although pre-quickening abortion was not self-considered homicide, it does not follow that the abortion was permissible at common law, much less that it was legal right. Yeah, this is not quite flow. It's a little bit tenuous. If it's not homicide, it's in a different category. If it's not homicide, if we're concerned about the ending of life, then that would be homicide. And as to pre-quickening, if they don't treat it as homicide, then maybe it's not special after all, because remember, one of the things the Supreme Court said earlier was that Roe and Casey and Dobbs are different because they deal with this potential life or potential human life. It's different because of that reason. Well, if it is different because of that reason, right, if the common law doesn't treat it as homicide, then maybe it's not special before that point. There's a little bit of reasoning here that's a little weak. Quite to the contrary, in the 1732 case mentioned above, the judge said of the charge of abortion with no mention of quickening, he had never met with a case so barbarous and unnatural. Similarly, an incident from 1602, which did not distinguish between pre-quickening and post-quickening, described abortion as pernicious and against the peace of Our Lady. Even if these cases are true, it's two cases. And we just saw, for example, in the Supreme Court's analysis of the Second Amendment right, when it came to, court cases dealing with carrying of firearms and so forth and so on, that there might be some cases in history that seem to potentially suggest that carry of firearms might have been illegal. But the Supreme Court said, and I think quite appropriately, that those cases are too few between, and too ambiguous to represent any kind of consensus that would potentially read on our current rights, right? We're trying to define the right to keep and bear arms, what it means. Okay, well, we're able to find maybe a couple scattered decisions in the common law that suggest potentially the right to carry was not a right. Now, first of all, you could criticize those decisions on its own terms. So you can say, well, those decisions don't say that, which is a valid point of view. But then you could even assume the premise. You could say, okay, let's assume they do say that. Let's assume that they do say, those cases actually do say that the right to carry is illegal. Yeah, and the Supreme Court says it's just not enough, and I think they're right. If you're trying to determine something, a few scattered cases from a few scattered judges isn't going to do a trick. Because you can find that in our case law today. You can find the odd district court, or even a couple odd district courts that do something occasionally. It doesn't mean that represents any sort of broad consensus. It could mean the courts are just wrong, which, is what we have courts of appeal for. So it's like, yeah, we're not going to use a couple scattered decisions that seem to maybe possibly suggest it as undercutting the entire concept of what's lawful. But then the Supreme Court, at least in the majority opinion, kind of goes back on that idea here. They're like, okay, well, I found a decision from 1732 and a decision of 1602, and they don't mention the fact that it's pre-quickening or post-quickening. I'm like, well, okay. First of all, I can attack it because, they didn't really mean that. The judges were just being a little bit sloppy in their writing, which isn't exactly the first time ever. So the fact they didn't mention pre-quickening versus post-quickening, they were sloppy in their writing, or they thought it was so obvious they didn't bother to mention it. But even if they did literally mean what they wrote, which is a whole nother set of premises, it doesn't flow that these two cases are suggestive of an overall trend. So I think the Supreme Court makes a mistake here by suggesting that these two cases in some sense dictate the outcome of this case. It doesn't quite make sense to me. That the common law did not condone even pre-quickening abortions. It's confirmed what one might call a proto-felony murder rule. Hale and Blackstone explained a way in which a pre-quickening abortion could give rise to the level of homicide. Okay, let's give this a shot. If we can find a way to make a pre-quickening abortion a homicide, this is more promising. Hale wrote that if a physician gave a woman with child a potion to cause an abortion, and the woman died, it was murdered because the potion was given unlawfully to destroy the child within her. Okay. I don't know that quite flows from a felony murder rule, right? The felony murder rule, we'll just read more because they're about to explain it. In the case of the abortionist, Blackstone wrote, the law will imply malice for the same reason it would imply malice if a person who intended to kill one person actually kills a different person. If a person shoots A and misses him, but kills B, this is murder, because the previous felony intent, which the law transfers from one to another. This is the case where one lays poison for A, and B, against whom the prisoner has no intent, takes it and kills him. This is likewise murder. So also, if one gives a woman with child a medicine to procure abortion and operates so violently as to kill the woman, this is murder in the person who gave it. And then they say Blackstone and Hale did not state this is a rule that would require the woman to be with quick child, only with child. And as to this, I say, if this is what Blackstone and Hale are writing, Blackstone and Hale are wrong. Now, Blackstone and Hale, as the court mentions, and is completely correct, Blackstone and Hale are some definite OGs when it comes to originalism and originalism understanding. So, contradicting Blackstone and Hale is kind of, slightly, you got to it's a little bit of hubris, right? I'm about to criticize some OGs, but, if I think Hale and Blackstone are wrong, I'm going to tell you I think Hale and Blackstone are wrong, which I'm going to do right now. Right? They're right in their fundamental premise. They're wrong in their conclusion. They're correct that if I try to kill person A and I do kill person B, I'm guilty of person B. My intent was the murder of person A. My intent follows the bullet. Attempting to shoot person A and killing person B, my intent follows the bullet. Or, if you prefer, my intent follows the poison, which is their other example, right? In attempting to poison person A for the purpose of killing them, my intent follows the poison. So, if it's actually drank by person B and they die, having intended to poison person A with the malicious intent that they die, right? You're there. But this only kind of really works if person A is a person in the first place, right? For me to have the transferred intent. It only kind of works because person A is a person. I intended to kill the person A, who is a person to which the homicide is illegal, right? And person B dies. It only kind of works if person A is a person. So if my intent is to kill the woman with child, if my person is to kill the child and a woman with child, and it operates violently as to kill the woman, this is murder. In a proto-felony murder rule, it kind of only really works if I'm trying to kill, if person A, the fetus, is a living person, right? Or it's like, okay, well, maybe it's just a felony against the person, right? So if you like the felony murder, right? Okay, so I'm intending to, so if we're trying to go from just transferred intent murder to felony murder, so if we're trying to go from transfer intent murder to felony murder, I'm just trying to commit a felony against person A, incidentally an inherently dangerous felony. And in my attempt to commit the inherently dangerous felony against person A, I kill person B, then my intent for the inherently dangerous felony carries over. And again, this only works if I'm intending to commit an inherently dangerous felony against person A. It only really works in that situation. The underlying felony still has to exist in the felony murder. And I can only commit a felony against a person, right? Especially in this example. So this doesn't really make sense unless you think the child in the womb is already a person, which as to post-quickening, you're there. But as to pre-quickening, I'm not sure. And then again, even Blackstone and even Blackstone isn't saying it's a pre-quickening child. He simply says a woman with child. Now, the Supreme Court plays fast and loose here. The Supreme Court says, notably Blackstone, like Hale, did not state this proto-felony murder rule to be that a woman with a quick child, only that a woman be with child. They play fast and loose. it is quite possible that Hale and Blackstone thought it was just so obvious that quick child that they didn't need to say it. Right? No person reading this at the time would understand child to mean anything other than quick child. So they didn't really say it because why bother? And the Supreme Court takes the absence of them saying quick child like they meant pre-quick child. And they didn't say pre-quick child, they just said child. So the question is, as always, what did they mean when they wrote it? Because if we're going to do this originalism thing, let's do it all the way through. The Constitution means only what it means when it was written. Right? So Blackstone and Hale only mean what they mean when they wrote it. The words only mean what they meant when they wrote it. So here's the question. They didn't say pre-quick child. So they didn't mean that. They just said child. So the question is, do they mean both pre and post-quick child? Or did they mean just child? Post-quick. And it's not exactly obvious from the text. So I think it's quite possible that Blackstone and Hale didn't mean what the Supreme Court is saying. And they are using a trick to substitute one meaning for another. So first of all, you can say Blackstone and Hale were wrong, or you can say they were right and simply meant something that the Supreme Court is treating as though they didn't mean it. So there's a couple ways to parse this here, and I think the Supreme Court is playing a little fast and loose here with this analysis. So yeah. In this country, the historical record is similar. The most important early American history of Blackstone reported the statement that abortion of a quick child was a heinous misdemeanor. Quick child, And some manuals repeat Hale's and Blackstone's statement that anyone who prescribed medication unlawfully to destroy the child would be guilty of murder. But what child, though? Do we mean quick, or do we mean both quick and not? Or more to the point, what did Hale mean and what did Blackstone mean when they wrote it? The Supreme Court is being a little fast and loose here, in my humble opinion. The original ground for drawing a distinction between pre- and post-quickening abortions is not entirely clear. Well, it's not that hard to imagine a reason why. Because it's similar in concept to elements that can be found in other religious law. I'm not an expert on such things, but my understanding vaguely of Islamic law is 40 days, I believe, if memory serves roughly correctly. It's been a while. Where the child is deemed to have been imbued with, personhood or sanctity thereof. And Christian law seems to be on similar track, although they draw the line at a different point. And these are where some of these first laws were written and conceived of. So why that point and not other point? Well, that was the point in which, for religious reasons or otherwise, they thought that the child was imbued with a soul. Or whatever the equivalent would be. So if that was their rationale, then, okay. At the time, there were no scientific methods for detecting pregnancy in its early stages. And thus, at one court put it, until the period of quickening, there's no evidence of life. And whatever may be said of the fetus, the law has fixed upon this period of gestation as the time in which the child is endowed with life, because fetal movements are the first clear marked and well-defined evidences of life. Yeah. So here's another problem. The Supreme Court has, by its own terms, made very, very clear that as to its own decisions, legal rules remain even if the underlying rationales for them disappear. Only the Supreme Court can change the law. So if the Supreme Court announces a legal rule, even if the underlying logical underpinnings of that rule disappear, the legal rule remains. Okay, so why is that a problem? Well, here the Supreme Court says, all right, well, they wrote, until this period, there's no evidence of life. And fetal movements are the first and clearly marked, well-defined evidences of life. This was the logical factual basis for the pre-quickening versus post-quickening distinction. We have no evidence of life before this point. Therefore, we are going to say that this is when life begins. Okay, so what does that mean if we treat this like a Supreme Court decision? Even though medical technology has now evolved so that now we can determine signs of life, before this point, what would be the logical conclusion? The logical underpinning has disappeared, but the law doesn't disappear. The law remains intact. Right? That's what the Supreme Court said. Said it clearly. Even if the factual underpinnings disappear, the rule remains. So the factual underpinnings were, well, we can't determine when life begins. We're going to draw the line here. The factual underpinnings are now no longer relevant. Does that mean the legal rule disappears? Nope. Not according to the Supreme Court, it doesn't. But they're treating it like it does. They're treating it like the fact that now we have this new improved medical technology and now we can determine when evidence of life begins. This necessarily implies the legal rule disappears when the Supreme Court doesn't treat its own decisions that way. There is some inconsistency in its own treatments versus the common law treatment. Again, they're being a little bit fast and loose, in my opinion, here on this pre-quickening versus post-quickening decision. At any rate, the original ground for the quickening rule is of little importance. Is it, though? Is it of little importance? I mean, Supreme Court, with all due respect here, this is how we do common law. This is how we do law. When we talk about the right to keep and bear arms, when we talk about the right to freedom of speech, how many times have I talked to my chat about this? How many times have I told them? It's like, if we're going to talk about the freedom of speech, if we're going to talk about the freedom of religion, if we're going to talk about the right to keep and bear arms, what do we have to do? Well, now let's go do a trek throughout, the English common law to define what that is and figure it out from a historical analysis, which the Supreme Court incidentally just adopted like just now when it came to the gun case in NYS versus Dobbs. Right? It's like, yeah, let's go do that historical analysis, guys. But suddenly that historical analysis is of little importance for our present rules. Is it? I don't know, man. I kind of think it might be important. I think this is a little disingenuous. During that period, treatise writers and commentators would criticize quickening distinction as near in accordance with the result of medical experience during the principles of common law. It's the 19th century, though. It's the 19th century. It might be a little late. The Constitution is adopted 1791, where the Bill of Rights is at least. Right, so it might be a little late to deal with that. In contrast to lemon, what about lemon? I don't understand the question. Someone asked me about in contrast to lemon. I don't understand the question. I'm sorry. In 1803, the British Parliament made abortion a crime at all stages of pregnancy and authorized the imposition of severe punishment. Okay, is that in keeping with the common law? If not, is the fact that it's not a problem? Is this too late? We're not really dealing with this problem. In this country during the 19th century, the vast majority of states enacted statutes criminalizing abortion at all stages of pregnancy. By 1868, the year in which the 14th Amendment was ratified, 3/4 of states enacted statutes making abortion a crime even if it was performed quickening. Okay, but maybe that's too late. Because we're interested in rights that were adopted or not at the Constitution's finding. Like, if we're trying to squeeze this into the 9th Amendment, which, we're trying to find that this is a right that exists in the 9th Amendment, then 1868 is way too late for that. The 9 states that had not yet criminalized abortion, all but one did so by 1910. Maybe it's too late. The overwhelming consensus... Shit. I hate it when that happens. Damn it. Excuse me, I have to find my page. Give me a second to find the page I was at. I'm sorry. It'll take just a second to find the right page. Talk amongst yourselves. All right. The overwhelming consensus endured until the day of Roe was decided. But again, maybe the consensus is too late. Or maybe it's not. But we're not being... I think we're being a little fast and loose here. It's a weak part of the analysis. At that time, also by the time Roe's court's own court, a substantial majority of 30 states still prohibited abortion at all stages except to save the life of the mother. And although Roe discerned a trend towards liberalization in about 1/3 of states, those states still criminalized some abortions and regulated them more stringently than Roe would allow. They sure did. They sure did. The inescapable conclusion is this right to abortion is not deeply rooted in nation's history and traditions. See, again, it's a little bit fast and loose here. It's a little bit fast and loose. Now, you can still get to where you want to be, I think, but I think you're being a little bit disingenuous in the reasoning. Right? So to say that it wasn't illegal isn't maybe necessarily say there's a right to it. And those are two different things. Perhaps. But you're not really like quite getting there. You're doing a little bit of a magic trick, I think, and hiding the ball a little bit. And I noticed the trick, at least in my opinion. And it could be better. It's a weak part of the opinion. On the contrary, an unbroken tradition prohibiting abortion on pain of criminal punishment existed from the earliest days of common law until 1873. Yeah, but as to what kind of abortions? As to what, what were Blackstone and Hale writing about? What kind of things were they writing about? Blackstone and Hale, by their own terms, only are talking about things that happen if the mother gets hurt. Right? Even Blackstone or Hale are only saying, well, if the mother dies, or it gets hurt, then you have a crime. What if the mother doesn't get hurt or doesn't commit it? Then it also doesn't make sense. Right? So if we go back to what they were saying earlier in the sections of Hale, we go back to like this idea about this proto-felony murder rule, and another reason it doesn't make sense. All right. If one shoots A and misses him and kills B, this is murder. But what if B doesn't die either? It's still not murder, incidentally. If one shoots at A and misses him and also misses B, it's still not murder. If one intends to lay poison for A and also B doesn't drink it, it's also not murder. So in Blackstone's hypothetical, they say, well, if one gives a woman a child with medicine and it operates so violently as to kill the woman, this is murder. Well, what if the woman doesn't get hurt? What if the woman is unharmed? What then? Is it still illegal? Or not? Blackstone doesn't seem to say. I mean, the child dies, right? So, because in this proto-felony murder rule, if one shoots at A and misses him but kills B, this is murder. But what if you kill A? Right? If you kill A, it's murder. If you shoot at A, miss him, and hit B, it's murder. So if B dies, it's murder. If A dies, it's also murder. If you intend to poison person A and succeed and kill them, it's murder. But if you kill person B instead, it's murder. It's murder if you kill person B, It's murder if you kill person A. In the third hypothetical, we say you violently killed the woman. It's murder. But what if you don't? What if only the child dies? Is it still murder? It was in your first two hypotheticals. Person B died, it was murder. Person A died, it was also murder. Whether you shot at them or poisoned them. In your third hypothetical, you say, okay, the mother dies, it's murder. What if the mother doesn't die? Is it still murder of the child? Blackstone doesn't say so. So it doesn't quite work. The analysis doesn't quite work. How can it be? The reasoning doesn't quite work. I don't know if it's Hale, I don't know if it's Blackstone, I don't know if it's the way the lead is doing it, but the analysis just doesn't quite work. Something about it is wrong. And then they get into well, there was no evidence of life. This is why they fixed the line at that point. Yeah, but they fixed the line at that point. So their reasoning is irrelevant. At least according to the Supreme Court it is. The underpinnings may have changed. The underpinnings may have been undermined, but the legal rule remains. So, okay. That doesn't quite make sense. And then they say the original grounds is of little importance, is it? And then they start talking about 1803 in this country and 1868 and blah, blah, blah. And it's like, oh, maybe that's a little late. It doesn't quite, the reasoning isn't quite correct, in my humble opinion. So it's a weak part of the opinion. And then they have the temerity to say that the inescapable conclusion is that it's not deeply rooted. Inescapable? I don't know, man. I think you're being a little fast and loose over here. Respondents in their amici have no persuasive answer to this historical evidence. Neither respondents nor the Solicitor General disputes the fact that by 1868 the vast majority of states criminalized abortion in all stages of pregnancy. I'm sure they don't, but the question is, does that matter? Instead, some respondents are forced to argue it does not matter that some states prohibit abortion at the time. But the argument flies in face of the standard we've adopted in determining whether asserted right that is nowhere mentioned in the Constitution is nonetheless protected. No, it doesn't. That doesn't make any sense. That doesn't make any sense. It shouldn't matter. It shouldn't matter if the states prohibited abortion at the time Roe was decided, or when the 14th Amendment was adopted, because maybe it's just too late. That argument doesn't fly in face of the standard, because the standard is the time when the Constitution was adopted. What was true in 1791? 1868 is just too late. 1973 is way too late. So it doesn't fly in the face. You're just not being correct. None of the respondents in their amici are unable to show this constitutional right to adoption was established when the 14th Amendment was adopted. But they found no support for the existence of the right that predates the latter part of the 20th century. The latter part of the 20th century is too late. Why are we discussing it? Are we originalists or not, right? There's some weak parts of this analysis. I know I'm spending a little bit of time on this, and I hope you're bearing with me here, but I want to make sure to try to explain fully, as completely as I can, where I think the weaknesses are. Because I'm contradicting, potentially, not only Alito, and Thomas, and Gorsuch, and Barrett, and Kavanaugh, but also contradicting, potentially, Hale and Blackstone. So, it's a little bit of hubris. And so, to try to justify these questions and critiques of some OGs over here, I have to spend a little bit of time picking it apart and trying to illustrate what the problem is. So, yeah. Hopefully this makes sense. Hopefully I'm justifying my critique. So, yeah. Or at least showing why it kind of makes sense. So, okay, let's press on. The Solicitor General next supports that history supports an abortion right because the common law's failure to criminalize abortion before quickening means at the time of the founding and for decades thereafter, women generally could terminate a pregnancy, at least in early stages. But the insistence on quickening was not universal. See one case from North Carolina, 1880. What? I'm sorry, the text isn't on screen that I was just responding to. I apologize. I'll reread it. The Solicitor General next suggests that history supports an abortion right because the common law's failure to criminalize abortion before quickening means that at the time of the founding and for decades thereafter, women generally could terminate pregnancy, at least in its early stages, but insistence on quickening was not universal. See, for example, Slate v. Slade, 83 NC 6630. One court case that said, quickening isn't the line. And okay, so now you've got a case from 1880 in addition to those two other cases you mentioned before, like one from 16 whatever it was and one from 17 whatever, and now I got another decision from 1880. I'm definitely sold on these three random cases I were able to find out of the ether. This is definitely the foundations of the right. Let me tell you right here, you gotta be kidding me. We just dismissed this kind of bullshit when it came to the Second Amendment, and I think rightly so. We just dismissed rando case from rando court that said rando bullshit one time because, 1, 2, 3 courts, in the last 800 years does not exactly, speak to what the consensus was regarding the Second Amendment. The Second Amendment wasn't absolute because I found 3 cases in the last 800 years that said, this guy who was concealed carrying or open carrying is a total asshole and gets to go to jail forever. And the Supreme Court says, okay, well, even taking is true. Bullshit. We're not going to say that these 3 cases kind of finds the right, which I think, that totally makes logical sense. If we're going to say, if we're going to do this historical analysis, which I think we've got to do, right, if we're going to say that, if we find 1, 2, 3, a half dozen cases, that kind of say things that seem to contradict the overall thrust, well, maybe they're just wrong. They're outlier cases, I don't think one case every 100 years exactly is a rousing endorsement for these restrictions on the Second Amendment, the Supreme Court says. But they have no problem turning right around and saying, hey, I found 3 cases. And it totally guides my analysis going forward on the abortion right. Okay. If you say so. I'm not so sure about that one. Pressing on. But the insistence on quickening was not reversal, regardless that many of the states in the late 18th and early 19th centuries did not criminalize pre-quickening abortions, does not mean anyone thought the states lacked the authority to do so. But they didn't. They never criminalized it. And if it's not criminalized, what's the alternative? This is not a hard question, guys. If it's not criminal, what is it? If you said legal, you would be correct. If it's not criminal, The only alternative is that it's legal. Because, yeah. So that's kind of important there, I think, on that one. A little bit. Might be being a little bit disingenuous on that one, Supreme Court. Seems to me. Pressing on. When the legislatures began exercising their authorities as the centuries wore on, no one, as far as we're aware, argued the laws they were enacting violated a fundamental right. But maybe they did. Maybe no one at the time noticed. Are you suggesting that because no one at the time in the late 18th and early 19th centuries noticed that they were enacting laws contrary to a fundamental right means that it wasn't a violation of the fundamental right? Maybe no one noticed. Maybe just no one noticed that they were passing laws that were contrary to the fundamental right. I mean, the U.S. Supreme Court didn't decide the First Amendment existed until around the 1930s. So if the Supreme Court can kind of not discover the First Amendment for the first, 140 years or so, now more than that, like 160 years of the country's existence, and the Supreme Court could not notice for 160 years the First Amendment existed until around the 1930s, and Wickard v. Filburn, Cohen versus California, where Brandeis says, oh, look, there's this thing called the First Amendment, maybe we should pay attention to it. If the Supreme Court doesn't notice the First Amendment exists for like 140 years, maybe the fact that they didn't notice that they were breaking the Constitution in the late 18th, early 19th centuries is not exactly dispositive. Maybe they just missed it. I don't know. That is not surprising, since common law authorities have repeatedly condemned abortion, described it as unlawful, without regard to whether it occurred before and after quickening. See supra, pages 16 to 21. Yeah, I've seen pages 16 to 21 Supreme Court, and I was not unwaveringly convinced that is the thrust of the common law authorities. I think you are misreading, potentially deliberately, both Blackstone and Hale, and also potentially the law that exists. I'm not sure Blackstone and Hale, nor the cases you're citing, actually say what you think they're saying. I think you might be misreading all of them. They didn't mention whether it was quick or alive. Therefore, they must have meant both. I thought we're supposed to interpret things based on what they meant at the time. What did they mean? Did they mean quick? Did they, by not saying it, did they mean both? Or maybe they thought that it was so obvious they didn't need to say it. Or maybe even they were wrong. I don't know if two decisions is a basis for going on, but okay. Instead of seriously pressing the argument that abortion right itself has deep roots, I suppose you could try to argue that the not being illegal and it being a right are two different concepts, which I suppose if you want to go down that road, fine. But, maybe you should actually go down that road. I suppose you could argue that just because it wasn't illegal doesn't mean it was a right. You could try that. But, you might want to try to do that. Supporters of Roe and Casey contend that abortion right is an integral part of a broader entrenched right. Roe termed this right a right to privacy, and Casey described it as freedom to make intimate and personal choices that are central to a person's dignity and autonomy. At the heart of liberty is the right to define one's own concepts of meaning, the universe, and the mysteries of human life. The court does not claim this broadly framed right is absolute, and no such claim would be plausible. That's so disingenuous. That is so disingenuous. That is like all the people who are trying to regulate guns, who say, well, the Supreme Court says that the right to keep and bear arms is not absolute, and therefore it means we can do kind of whatever we want. Not absolute, and we can regulate it any way we want, are definitely not the same thing. I get endlessly frustrated in the Second Amendment analysis when some legislature or some politician or even some court says, hey, the Second Amendment isn't absolute. True proposition. Therefore, all the regulations are totally cool. Incorrect conclusion. Not absolute, and we can do anything we want are not the same thing. And the Supreme Court is kind of doing the same thing here. While individuals are certainly free to say and think what they want about the existence, meaning, the universe, and mystery of human life, they're not always free to act in accordance with those laws. That's true. They're not always free. That doesn't necessarily mean that they're not free in this case, though. License to act on the basis of beliefs may correspond to many instances of an understanding of liberty, but certainly not ordered liberty. Okay. These attempts to justify abortion through appeals to a broad array of autonomy and define one concept's existence prove too much. So now the Supreme Court's on better footing. Right? The Supreme Court's on better footing here. Right? So trying to find this inside of a concept of privacy, it doesn't really make sense. Trying to find this in a concept of autonomy doesn't really make sense. So the Supreme Court's on better footing here. Those criteria at a high level of generality could license fundamental rights to illicit drug use, prostitution, and the like. The libertarians at this point say, and the problem is, but yeah. None of these rights have any claim to being rooted in history. What sharply distinguishes the abortion right from the rights recognized in this case, on which Roe and Casey rely, is something both those decisions acknowledge. Abortion describes what those decisions call potential life and what the issues at this case call an unborn human being. Okay, but why is that difference important? They just take it. Okay. And then they say the Supreme Court actually has the temerity to say none of these other decisions cited by Roe and Casey involve the critical moral question posed by abortion. They are therefore inopposite. Danger, Will Robinson, danger. None of the other decisions cited by Roe and Casey involve the critical moral question imposed by abortion. Are we doing morals or are we doing law? Are we doing morals or are we doing law? Yeah, this is your problem. It's like you say, okay, none of these decisions involve potential life. And then I say, okay, why does that matter? And you say the reason it matters is because it's a critical moral question. You see the problem here? You see the problem? We're making an appeal to morality. We're making an appeal to morality at the bottom of this. In this decision, we're making an appeal to morality at the bottom of this. This conflates morality and law, which are best not to be conflated. And we are conflating them at the root base of this analysis. At the end, we hit a moral analysis, not a legal analysis. And I'm a proceduralist guy. I explained this from the beginning. I think in terms of procedure, and we just imported morality at the base of our chain of logical reasoning, and that makes the entire chain somewhat suspect because moral and laws are different. And so yeah, it's a problem. It's a problem. Defenders of Roe and Casey do not claim that any new scientific learning calls for a different answer to underlying moral questions. Are they, though? Are they moral questions? I thought they were legal questions. But they do not contend these changes in society require recognition of a constitutional right to obtain abortion. Without the availability of abortion, they maintain, people will be inhibited from exercising their freedom to choose the type of relationships they desire, and women will be unable to compete with men in the workplace and other endeavors. That doesn't flow, and I'm not sure is necessarily the best faith steelman argument of their stuff. You know, moral questions are an appropriate domain for the legislature, or at least a factor for the legislature to consider in passing legislation. Moral considerations and weighing various things. I mean, to some degree, all legislation involves moral considerations. Whether or not we fund research for this disease or that disease is in some sense a moral consideration. Whether or not we provide funding for this project or that project, whether or not we give money to help the homeless or to fight war or to deal with climate change or to whatever potentially implies moral considerations. So these are appropriate considerations for a legislature when they're considering laws, or at least can be appropriate consideration. But those are policy questions. Morals are appropriate as a factor in a policy-based determination, but that's for a legislature. This is a court. Courts do law. They don't do policy. There is some problem here at the base of this thing. Americans who believe abortion should be restricted press countervailing arguments about modern developments. They note that attitudes about pregnancy of unmarried women have changed dramatically, that federal and state laws ban discrimination on the basis of pregnancy, that leave for pregnancy and childbirth are now guaranteed by law in many cases, the costs of medical care associated with pregnancy are covered by insurance or government systems, as states have increasingly adopted safe haven laws by which women drop off babies anonymously, and that a woman who puts her newborn up for adoption today has little reason to fear the baby will not find a suitable home. That last part is factually questionable, but okay. Yeah. They also claim that many people will now have appreciation of fetal life, and many of those prospective parents who want to have a child view a sonogram. They typically have no doubt of what they see as their daughter or son. Both sides make important policy arguments, but supporters of Roe and Casey must show this court has the authority to weigh in on those arguments and decide how abortion must be regulated. They have failed to make this showing, and thus return the power to weigh those arguments to the people. This is the appropriate domain for moral arguments. So I agree as to that much. To the extent that they're appropriate at all, it's the appropriate domain of the legislature, not of the courts. So to the extent that we do need to make a moral calculus, it is not at the Supreme Court. But there's a problem because they do make a moral calculus. There is a moral calculus at the very bottom of this thing. They even say it this much. What sharply distinguishes the abortion right from the rights recognized in cases on which Roe and Casey rely is something both those decisions acknowledge. Abortion describes what those decisions call potential life, and what the law at issue now regards the life of an unborn baby being. None of the other decisions cited by Roe and Casey involve the critical moral questions posed by abortion. Roe and Casey are different because of the moral considerations that underpin them. But why are you factoring morality into this at all, Supreme Court? First of all, to the extent that those decisions are properly within the bounds of the legislature, yes, they do involve moral questions, to some degree. Why are you treating this one different? Why are you treating this morally different? There is some sort of flaw here, it seems to me, in some of this reasoning. This, of course, I am not necessarily saying the opinion is wrong, by the way. I'm just pointing out that there are some problems from a pure legal posture, which is what I do. There's some problems in my view in the posture. Also in the legal reasoning, there's some problems. I'm not sure that they are correctly interpreting the case law that exists from the 16th and 17th century. I'm not sure they're correctly interpreting Blackstone and Hale. I'm not sure even if they are correctly interpreting them, that those decisions or those writings are relevant, because they're so far and few between that I'm not sure it matters. I'm also not sure it matters very much about what happens in the late 18th and early 19th century vis-a-vis what the Constitution does or does not protect in 1791. So there's problems here in logic, in the legal reasoning. It's a little bit questionable. The dissent is very candid and it cannot show a constitutional right to abortion that has any foundation, let alone a deeply rooted one in this nation's history and tradition. The dissent does not identify any pre-Roe authority that supports such a right. No constitutional provision or statute, no federal or judicial precedent, not even a scholarly treatise. Nor is the dissent dispute the fact that abortion was illegal at common law, at least after quickening. We're conflating these things. It just is slightly, there's some flaw here. There's some flaws in this reasoning. Nor does it dispute that by 1868, a supermajority, 26 to 37 states, had enacted statutory criminal abortion at all stages of pregnancy. Is that too late in 1868? What does the Constitution speak to in 1791? I thought was the important question. What the states were doing in 1868 seems a little inopposite. And that by the late 1950s, at least 46 states prohibited abortion. Also seems a little inopposite to what the common law does or does not protect. Unless you think that, unless you're trying to make the proposition that because no one noticed for so long, it became embedded in the Constitution, which is the very thing you're trying to avoid in the first place in an originalism view. Right? You're trying to avoid, like, changing the meaning over time. But unless you're trying to say, well, because so many states made it illegal for so long, that somehow changes the understanding of the Constitution, which is not an originalist posture. There's some questions here. Since failure to engage with this long tradition is devastating to its position, we hold that establishing method of substantive due process analysis requires that unenumerated right be deeply rooted in its nation's history and tradition before it can be recognized as a component of liberty. But despite the professed fidelity stare decisis, it fails to seriously engage with the important precedent which it cannot satisfy. Yeah, if you're trying to prove that Roe versus Wade is garbage, though, that's pretty easy too. Roe versus Wade is totally based on nothing. Roe versus Wade is garbage. Casey versus Planned Parenthood is a completely fractured mess of a decision, so it's best probably ignored. So if you're trying to convince me that Roe versus Wade is incorrectly decided, then no problem. Because Roe versus Wade is based off of nothing. It's very hippie in its own language, to be quite honest. It's the emanations and penumbras. It's the shadows and shadows and shadows. And it's in the ether, man. It's in ether. It's where it's cool, man. Like, I can't deal with 1973 hippie. It's not a good way of not a good way of reasoning either. Sorry, no. And although this is far, far better than 1973 hippie, it's in the ether, man. It's in the ether, man, of the penumbra, man. You just gotta read it, man. You know? Yeah. Oof. Although this is far, far better, it's not beyond criticism. All right. Because this dissent cannot argue the abortion right is rooted in nation history tradition, contends that constitutional tradition is not captured whole a single moment, and which is exactly the problem I'm trying to avoid. The dissent is saying that the constitutional tradition is not captured in the whole at the single moment. That's exactly what I'm trying to do. I'm trying to capture it in the whole moment. I'm trying to capture it at 1791. I'm trying to fix the words on the page, man. 1791. Seal it. Done. You know, and now you start talking to me. This is bizarre, a little bizarre, right? It's like, oh, the dissent over here is trying to say, oh, the meaning of the Constitution isn't fixed. And we're totally able to determine that abortion isn't a right because in 1950, 46 states had abortion be illegal. How do those two thoughts square in the same circle? It's not quite clear. Okay. Yeah. The largely limitless reach of what dissenter standards illustrate is by the way they apply here. First, the long sweep of history imposes any restraint on the recognition of unenumerated rights, then Roe is surely wrong, since abortion was never allowed in the majority of states. Right, which is exactly why you shouldn't be factoring that into the analysis. What the hell are you doing, Supreme Court? What are you doing? You are, what? The largely limitless reach of the dissenter standard is illustrated by the way they apply it. First, the long sweep of history imposes any restraint. Then Roe was surely wrong, since abortion was never allowed in the majority of states for over 100 years before the decision was handed down. Right, but then you yourselves relied on that decision, those decisions like 5 paragraphs ago, to show that, okay. The majority itself relied on the exact decisions. Okay. Second, it's impossible to defend Roe based on prior precedent because all precedent Roe cited, including Griswold and Eurostat, were critically different for a reason we've explained. None of those cases involve destruction of what Roe called potential life, but that only matters in so much as it's a moral factor, which the Supreme Court isn't really supposed to be factoring into this equation, so they're not critically different. They're only critically different for a reason you're not allowed to consider, which is the moral consideration. This is a lot better than Roe, though. For whatever problems Roe has, well, let me try that again. For whatever problems this has, Roe is just completely fucked up, meaningless bullshit. Like, there's some weaknesses here. There's some points of attack and criticism here. But, like, this is still way better than Roe and Casey, which are full of shit. I mean, they don't even purport to be based on anything. At least these purport to be based on something involving reason and logic, which then I can attack in reasonable and logical ways. I can say, oh, you're a little bit weak in this point of the analysis. This is a little bit shaky. This point of the analysis seems a little contradictory. I'm not so sure you're reading this one right here. I'm a little think you're making a mistake. I see some problems along the way of your chain of analytical reasoning. But at least we're doing a chain of analytical reasoning. Holy shit, right? Where Roe is just like, whoa, man. Penumbra. It's penumbra. Which, you know, this might have some problems. It might not be perfect. But at least, you know, it's based off of something resembling logic, reason, that we can actually address in a reason and logical way. So, this is, we'll take this, I guess, because it's the internet. The most striking feature of the dissent is the absence of any serious discussion of the legitimacy of the state's interest in protecting fetal life. This is evident in the analogy that the dissent draws between the abortion right and rights recognized in Griswold, Aristat, Lawrence, and Obergefell. Perhaps this is designed to stoke unfounded fear or a decision will imperil those rights, but the dissent's analogy is objectively for a far more important reason. What it reveals about the dissent's views on the protection of Roe, what called potential life. The exercise of these rights does not destroy potential life, but abortion has that effect. Why is that important? Why is that important? It's only important because of moral reasons. Okay. That view is evident throughout the dissent. The dissent has much to say about the effects of pregnancy on women, the burdens of motherhood, and difficulties faced by poor women. These are important concerns. However, dissent advances no similar regard to the state's interest in protecting prenatal life. Right. And insofar as these are moral considerations, they're the appropriate domain of the legislature. This is fine. Right? This is an appropriate domain of the legislature, so, like, it's not appropriate for us, which is a slightly better way of doing this opinion, it seems to me, right? I mean, the history is ambiguous at best. You know, it didn't seem to be illegal, but there's no one saying, like, it was considered part of liberty, so, I mean, the Supreme Court is kind of getting at the right ideas. I think this isn't, like, critically wrong. I think it just could be rewritten. I think there's just some sloppy parts of the analysis that could be improved. I think this is probably the right ideas. I just think there's some weaknesses that could be improved, or some slight rewordings or something to address some of these issues. So the Supreme Court's probably on the right track, all things considered. But there are a few points here that are worthy of note that could be improved upon. These are notes from the editor. Notes from the editor. These could be improved upon. A-. Good work. For reasons we discussed later, and given the opinion of Chief Justice, viability makes no sense. It was not adequately justified in Roe, and dissent does not even try to justify it, nor does it identify any other point in pregnancy after which the state is permitted to prohibit destruction of a fetus. That's fine. Yeah. Our opinion is not based on any view about what, if any, prenatal life is entitled to say about any rights enjoined after birth. The dissent, by contrast, would impose it. According to the dissent, the Constitution requires states to regard the fetus as lacking even the most basic rights. Until an arbitrary point in pregnancy, nothing in the Constitution authorizes the court to adopt that theory of life. I tend to agree. The quickening analysis leaves a little bit to be desired. And then they talk about stare decisis, which, you know, that makes a lot of sense because stare decisis reasons don't really work. Because, well, there's no reliance interests, because most abortions are not planned, because, you know, that'd be a little weird. So it's a little bit hard to have a reliance interest on something that you're not planning for. That's the nature of reliance interest is something you're planning for. You're relying on it because you're planning on it. So since abortions are not really planned, you can't really have a reliance interest on it. So yeah, okay. Our most important decisions have overruled prior precedent. Roe versus Wade is garbage and needs to disappear. I'm fine with that. This case, although it has its problems, is probably correct. I mean, the quickening analysis, I mean, post-quickening, you're there. To banning that, you're there without breaking a sweat. So you're only trying to find the pre-quickening stuff, and all you need to really do is kind of say, well, the history doesn't seem to really speak to this either way, which, you know, it doesn't really seem to speak to it either way. So therefore, it must be an open judgment by the legislature, and you're kind of there, right? It doesn't really criminalize it, but then again, it doesn't say it can't be. One of the reasons that maybe it wasn't criminalized is, again, because it would be really hard to detect when it happened, because, you know, a person wouldn't even know if they were pregnant or not necessarily before quickening. So, you know, so yeah, it might not even be apparent. So the law just never had to deal with it one way or another. So the slightly better analysis is that the history is ambiguous. It was neither illegal nor explicitly sanctioned by anything. So it was not a crime, but it also was never expressly a right. And so therefore, if it's ambiguous, it's open to the legislature because the Constitution only protects rights. And so, although it was never criminal, it was certainly not a right, and you're kind of there. And the Supreme Court's trying to do that analysis, it's just making some problems along the way. So I think they have the right idea, perhaps slightly imperfect in their processes, but that's okay. I'm here to help. All right, and then let's see what else they say. So they talk about, the infamous decision Plessy versus Ferguson was one decision. It betrayed our commitment to equality and was egregiously wrong. And Solicitor General agreed that oral argument should have been overruled at its earliest opportunity, and Roe was also egregiously wrong. Now, this makes logical sense, but it's a little bit inflammatory. I mean, I agree Roe was egregiously wrong because it's based on nothing whatsoever. I mean, Plessy was at least closer to being based on something for all of its wrongness. But this is like, the comparison is a little inflammatory, so I'm not sure it's advisable. Roe was on a collision course with the Constitution from the day it was decided. It perpetuated errors. Yeah, I mean, it was on a collision course with itself because of medical advancements. It didn't really make sense. When the court usurped the power to address the question of profound moral and social importance, the Constitution unequivocally leaves to the people, or at least doesn't inherently strip them of it, because the Constitution doesn't take it away. Right? The 10th Amendment says all power not given to the federal government is retained by the states or the people, right? The 9th Amendment says there's rights we didn't mention. The 10th Amendment says all power that's not given to the federal government belongs to the people, so the power belongs to the people. So if it's not the 9th Amendment right, it's the 10th Amendment right. So the question is, which is it? Is it a 9th Amendment right or is it a 10th Amendment right? It must be one of them. It's got to be one of them. Either it's a right that we didn't expressly mention and it's in the 9th Amendment, or it's not, in which case the power belongs to the people and they can do what they will. So what's your pleasure, 9th or 10th Amendment? Pick one. Well, it's not a 9th Amendment right, because, you can't really find it as a right that was considered as a right. So therefore, it must be 10th Amendment. So there's another way to get to where you're trying to be at the end of the day. Okay. Roe found the Constitution impermissibly conferred a right to obtain abortion, but failed to ground its decision in text, history, or precedent. Roe is very readily attackable. Roe is just a very bad opinion. It relied on erroneous historical narrative. It devoted great attention to and presumed reliance on matters that have no bearing on the meaning of the Constitution. It disregarded fundamental difference between precedents on which it relied and decisions of this court. That's a weak point, in my view. It concocted an elaborate set of rules with different restrictions for each trimester, but didn't explain how this variable code could be teased out of anything in the Constitution. That's for damn sure. Even if somehow a right to an abortion is somehow in there, how the hell are you coming up with a trimester framework on a constitutional basis? That doesn't make any sense. The weaknesses in Roe's reasoning are well known. They sure are. They've been well criticized for a long time. Without grounding the constitutional text, history, or precedent, it imposed on the entire country a detailed set of rules like one might be found in legislation. Yeah, I mean, the Supreme Court can't really do that. And it's not for the Supreme Court to do. They create something that looks suspiciously like legislation. That is, yeah, that's a bingo. Can't do that, Supreme Court. For sure. The elaborate scheme was the court's own brainchild. Neither party advanced the trimester framework, nor did either party or any amici argue viability should mark the point of, the Supreme Court just invented this shit up. It said the right to abortion was contained in the right to privacy. The right to privacy isn't expressly mentioned. The right to abortion isn't expressly mentioned. And then on top of all that, it then put in a detailed trimester framework based on viability that also was based on nothing. So this is like multiple levels of hearsay, kind of. It's like, it's levels of inferred stuff that's just drawn from nothing. It's horrible. This decision, although it has problems, is drawn from things. It has weaknesses, it has points of attack, but that's because it has a logical chain of reasoning that can be addressed and say, oh, these are a little bit weak. And even though there are parts of it that are a little bit weak in its foundations, of course, it doesn't make the entire thing crumble any more than weaknesses in the foundation of a structure necessarily make the structure crumble. Just because the foundation isn't perfect doesn't mean the structure doesn't survive. It's like, oh, this could be a little bit improved, this could be a little bit better, this could be a little bit, these are some problems, but, it's fine. The structure will survive. So, yeah, this is a lot better for that reason. Not only did the scheme resemble the work of legislation, but made little effort to establish how these rules could be deduced from a source that we usually base. Yeah. Roe's failure to even notice the overwhelming consensus of state laws in 1868 is striking, and what said about the common law was wrong. Relying on 2 discredited articles by an abortion advocate, the court erroneously suggested, contrary to Blackstone, Koch, and Hale, Blackstone, and a wealth of other authorities, the common law had probably never really treated post-quickening abortion as a crime. Again, they're conflating the two, right? Post-quickening abortion, I think you're there. You're there in the common law. If you're trying to convince me the common law prohibits post-quickening abortion, I think you're there. You got that. The other one's a little bit weak. Another super chat. Mary said the 2 houses and parties failed to address it and lazily bundled it to the Supreme Court. I mean, yeah, to some degree. What Roe did not provide for was any cogent justification for the lines it drew. It certainly did not. Why, for example, the state has no authority to regulate first trimester abortions for the purposes of protecting women's health. The court only explained that the mortality rates for abortion at that stage were lower than mortality rates for childbirth, but the court did not explain why mortality rates were the only factor the state could legitimately consider. True. Many health and state regulations aim to avoid adverse consequences short of death, and the court does not explain why it departed from normal rules that courts defer to judgments of legislatures in an area fraught with medical and scientific uncertainty. True. An even more glaring deficiency was Roe's failure to justify the critical distinction it drew between pre- and post-viability abortions. Here's the court's entire explanation. With respect to the state's important and legitimate interest in potential life, the compelling point is at viability. This is so because the fetus is then presumably has the capable of a meaningful life outside the womb. As Professor Lawrence Tribe, who is a liberal's liberal, has written, clearly this mistakes the definition for a syllogism. The definition of viable fetus is one that's capable of surviving outside the womb, but why is the point at which the state's interest becomes compelling? If, as Roe has stated, a state's interest in protecting prenatal life is compelling after viability, why is this interest not equally compelling before viability? Good questions, Lawrence Tribe. Roe does not say, and no apparent explanation is apparent. Yeah. This arbitrary line has not found much support among philosophers and ethicists who have attempted to justify a right to abortion. Some have argued a fetus should not be entitled to legal protection until it acquires characteristics they regard as defining what it means to be a person. Among the characteristics that have been offered as essential attributes of personhood are sentience, self-awareness, and the ability to reason, or some combination thereof, but by this logic it would be an open question on whether even born individuals, including young children or those affected with certain developmental or medical conditions, merit protections as persons. Yeah, these are arguments that prove too much. If you try to base personhood on sentience, self-awareness, ability to reason, or some combination, there are some people who are born who may not necessarily meet those standards, and you're in a real pickle. But even if one takes the view of personhood begins when a certain attribute or combination is acquired, it's very hard to see why viability should mark the point where personhood begins. This as well. Yeah. The most obvious problem with any such argument is viability is heavily dependent on factors that have nothing to do with the fetus. One is that the state of neonatal care at a particular point in time. Due to development of new equipment and improved practices, the viability line has changed over the years. In the 19th century, a fetus may not have been viable until the 32nd or 33rd week of pregnancy or even later. When Roe was decided, viability was gauged at roughly 28 weeks. Today, respondents draw the line at 23 or 24 weeks. So according to Roe's logic, states now have a compelling interest in protecting a fetus with a gestational age of, say, 26 weeks, but in 1973, states did not have an interest in protecting an identical fetus. How can this be? This is a very good question when we're talking about a constitutional provision. Now you have a constitutional provision changing on something that's floating with technology, which is a little bit uncomfortable. Viability also depends on the quality of let's try that again. Viability also depends on the quality of available medical facilities. Thus, a 24-year-old weak fetus may be viable if a woman gives birth in a city with hospitals that provide advanced care for very premature babies. But if a woman travels to a remote area far from such hospital, the fetus may no longer be viable. Yeah, so on the line, viability becomes dependent on access to resources. On what ground could the constitutional status of a fetus depend on the pregnant woman's location? True. And if viability meant to mark having a line having universal moral significance, can it be a fetus that is viable in a big city in the United States has a privileged moral status, not enjoyed by identical fetus in a remote area of a poor county or a poor country? In addition, as the court has explained, viability is not really a hard and fast line. A physician determining a particular fetus's odds of surviving outside the womb must consider a number of factors, including gestational age, fetal weight, a woman's general health and nutrition, the quality of available medical facilities, and other factors. It's thus only with difficulty a physician can estimate a probability of survival. And even if each fetus's probability of survival could be ascertained with certainty, saying a probability of survival that should count as viability is another matter. Is a fetus viable with a 10% chance of survival, 25, 50%? Can such judgment be made by a state, and can a state specify a gestational age limit that applies in all cases, or must these difficult questions be left entirely to an individual's attending physician on particular facts? The viability line makes no sense, and it's telling that other countries have eschewed it. Yeah, these are problems with viability. It's like, what is viability? Who gets to define it? What level of threshold? And so forth and so on. And when you're trying to determine constitutional lines, yeah. Yeah. All in all, Roe's reasoning was exceptionally weak, for sure. And academic commentators and those included who agreed with the decision in a matter of policy were unsparing in their criticism. Roe's been attacked by everyone. John Hart Ely famously wrote that Roe was not constitutional law, and he gave almost no sense of obligation to try to be. Archibald Cox, who served as Solicitor General under President Kennedy, commented that Roe reads like a set of hospital rules and regulations, and that neither historian, layman, nor lawyer will be persuaded are part of the Constitution. And Lawrence Tribe, liberal, wrote that even if there's a need to divide pregnancy into several segments with lines that clearly identify limits of governmental power, interest balancing in the form of a court pursues fails to justify any of those lines drawn. Mark Tunichet termed Roe a totally unreasoned, justified opinion. This is definitely accurate of the state of the law on these things, because as to the 856 of you who are currently watching, thank you very much. Remember to hit the like, comment, subscribe button. We do appreciate all the support when we're trying to cover controversial decisions and trying to really analyze them and really dive into them and really try to see what they are saying and what their reasoning is. And it's only with your guys' support that I can justify the time and energy and stuff that goes into these things. So I really appreciate it. Our precedent counsels that another important consideration deciding whether precedent should be overruled is whether it's workable. Yeah. Problems begin the very concept of undue burden. As Justice Scalia noticed, there's determining whether a burden is due or undue is inherently standardless. You better believe it. Casey provides no answers to these questions. Instead, a regulation is unconstitutional if it imposes a substantial obstacle in a large fraction of cases, which is relevant, but there's obviously no clear line in which a fraction is large and one that is not. And large is in the eye of the beholder. The ambiguity of undue burden test also produced disagreement in later cases. In Whole Women's Health, the court adopted a cost-benefit interpretation of the test, stating that the rule announced in Casey requires that courts consider burdens a law imposes on abortion access together with benefits those laws confer, but 5 years later, a majority of justices rejected that interpretation. It's been a mess. The experience of the Court of Appeals tells us it's a mess. It sure does. We'll skip that analysis. The courts of appeals have experienced particular difficulty in applying the large fraction of relevant case test. They've criticized the assignment while reaching unpredictable results, and they've candidly outlined Casey's many problems. The courts of appeals have had a really tough time with applying any of this for sure. Casey's undue burden test has proven to be unworkable and plucked from nowhere. This is true. Like, if you're looking for your reasons to overrule Casey and Roe, you're there. If you're looking for reasons to overturn Casey and Roe, you're there. I mean, it's unworkable. It's not constitutionally based. The frameworks makes no sense. They can't be applied. They test themselves are inherently subjective. They move around. Nothing makes any sense. It's not moored on anything. It's a complete nightmare fiction that doesn't work. If you're trying to justify overturning Roe and Casey, they're just bad decisions. All right. And then they note our decision returns the issue of the abortion to legislative bodies, which, in the absence of anything solid, which the Constitution is designed to fix in time. So, although I have problems, as we've noted, in parts of the reasoning, and there's some weakness here, and there's some problems in some of the aspects, sort of one of the bottom line considerations, or at least one of the aspects of considerations that come to my mind, is the Constitution is, by its very design, designed to fix certain things in time. It's designed to solidify. And so it solidifies to some degree that which was already solid. For example, as we've pointed out many times on this channel, the First Amendment analysis didn't appear, it didn't come from any, wasn't just created, it was recognized, right? It's the freedom of speech. The First Amendment doesn't create, it recognizes that already existed. The First Amendment was solid before the First Amendment was written. The First Amendment just recognizes the solidity. It was a well-established thing with its boundaries in the history. And the Second Amendment likewise. It's solid. Right? It recognizes that solidity. The Constitution is designed to solidify. And although there are points of criticism in this case, in this analysis, as we've noted throughout, what can best be said is that those points, although correct those points of attack, although valid in my view, don't really lead to changing the ultimate decision of this case, because the ultimate decision of this case is give it to the people, give it to the states, which has to be the correct answer if you can't find anything solid. So, this opinion has some weaknesses, but there's nothing solid to say this is a decision removed from people. I mean, the Constitution says, everything not given to the federal government is given to the states and to the people. It's right in the 10th Amendment. So the 10th Amendment says this belongs to the states or the people. In the absence of it being in the Constitution, the 10th Amendment says in the absence of it being in the Constitution, it belongs to the states or the people. All right? So your default assumption has to be it belongs to the states and the people. Right? The Constitution, the federal Constitution, is a constitution of enumerated powers. We've discussed this in a lot of other contexts. We've also discussed this in the context of what we call police power sometimes, right? The general power to do stuff. The general power to do stuff belongs to state governments, not the federal government. The federal government is a government of limited and enumerated powers. The federal government only has as much power as the federal Constitution gives it. It doesn't have any more. The Constitution creates the federal government. It bestows power to the federal government. Those powers didn't emerge from nowhere either. Those powers were powers that belonged somewhere in the first place to the states individually. That's the nature of our federalism. It isn't the federal government that gives states power, it's the other way around. It isn't the federal government that gives states power. It's the other way around. The states give the federal government power. In the first instance, all the power belongs to each individual state. All power belongs to each individual state. Each individual state is as an independent country. In the first instance, they have all the power. They have, by their choice, given power to the federal government. It is a lot of power. It is so much power we don't think of the states as independent nation states anymore. Rather, even though they're sovereign, but we don't really think of them as independent nation states like we do, for example, Europe, right? They're not independent enough for that. So they've given a lot of power to the federal government, but it's still limited power to the federal government in a limited federal constitution. So if it's not there, it is where it started, its life in the states, right? So then that's what the 10th Amendment says. And it's truism. If it's not in the federal constitution, it belongs to the states or the people, because that's where everything started. So the abortion is not in its explicit text. I mean, this part cannot be denied. So if it exists anywhere, it must exist in the 9th Amendment, because that's the one that says there's rights we didn't mention. And can you find a right to an abortion that is solid enough? Can you find that right solid enough in the history? And the answer is no. So even though there's problems in the analysis, for the reasons we've noted, the ultimate conclusions are correct. In the absence of the solidity, in the absence of the certainty that fixes this as part of the federal constitution and resolves this issue beyond the scope of legislative power, it's a matter of legislative power. And so my criticisms of some of the aspects of this case do not cause me to disagree ultimately with its holding. So, but we still have to do the analysis along the way. Right? We still have to really, be good legal educators. We still have to be good law students. We still have to criticize the Supreme Court, and we still have to poke holes at it, and we still have to test it, and still say, this doesn't quite make sense, or this is a little weak, or this is a little whatever, but this doesn't quite work, and here's some weaknesses in your analysis, and blah blah blah. We still have to, they're not God. They make mistakes, and it's like, you made mistakes in some of these propositions, but it's okay because you can get there some other way. And we here's another way to get there that makes more sense, at least to me. So hopefully all that makes sense. So we therefore return this from the federal constitution because it is not solid enough to be solidified there. If it's not solid enough to be solidified there, the only alternative is that it must belong to states where it belonged in the first instance. So that must be correct. If it is not a constitutional right, as Roe wrongly decided, because Roe's garbage, and if it's not a right for some other reason, because the history doesn't really quite work to create it, then it must mean this belongs to the people. So that's where we give it. Makes sense. And then they note that, of course, that 26 states have asked us to overrule Roe, and this will return the debate to the people. Roe must be overruled and returned to the people. And I think that's probably correct. And I don't think, incidentally, that we know we have any real idea. I don't think we have any idea what happens in the future in terms of the debate. I don't think the federal Congress has power to pass legislation either way. Although I'm not 100% sure on that, because we're going to run into conflicts. And so the question is, can the federal government do anything about it? And I'm not so sure. Their only real authority is interstate commerce, and this doesn't seem commerce-y. But I don't know that the federal government can do anything about it either way. I don't know that they can require abortion, and I don't know that they can forbid abortion. So I'm not sure the federal government has the power either way. This is up to the states, it seems, irrevocably. So I'm not sure Congress can pass any legislation, not that they won't try. But I don't think it's going to go anywhere in the end. But we'll see. And then what happens from there as it's left to the states? Who knows? I don't think we know what the future is going to be. I don't know that we don't know that all 50 states won't allow abortion or all 50 states won't ban abortion. I don't know what's going to happen next. I don't think anyone does. And I think we'll all be surprised in the end, one way or another. Whatever we think is going to happen is almost certainly not going to be it. So we'll see. As the debate happens, it's going to be an interesting ride. They then note that the proper standard is rational basis for the states, which is correct, which basically means anything they want to mean. Yeah. A law regulating abortion, like any other health and welfare law, is entitled to validity. It must be sustained if there's any rational basis in which a legislature could have thought it would have served legitimate state interest. This is pretty bold. Yeah. These legitimate interests include respect for preservation of prenatal life at all stages of development, the protection of maternal health and safety, the elimination of particularly gruesome or barbaric medical procedures, the preservation of integrity of medical profession, the mitigation of pain, and the prevention of discrimination on the basis of race, sex, or disability. Basically, the states can do anything they want. Someone asked, have I read up on Blackstone's papers? I don't believe I have. I'm not sure which papers you're referring to. But thank you for the question. And then I thought I would just spend a moment dealing with Justice Thomas's concurring opinion, because everyone's completely freaking out about what Justice Thomas wrote, even though they really shouldn't be. So I thought we'd spend a minute dealing with that, because everyone's panicking, because, yeah, they don't understand Justice Thomas. But that's okay. I do, because I've read enough of him to understand him. Not that I always agree with him, but I understand them. Okay, so now we're going through some histories of laws, and we can just skip this stuff. All right, so Justice Thomas writes the following on a concurring opinion. Excuse me. Okay. So Justice Thomas concurs, and he writes, I write separately to emphasize a second, more fundamental reason why there's no abortion guarantee lurking in the Due Process Clause. Considerable historical evidence indicates the due process of the law merely required executive and judicial actors to comply with legislative enactments and common law when depriving a person of life, liberty, or property. Other sources, by contrast, suggest that due process law prohibit legislatures from authorizing the deprivation of a person's life, liberty, or property without providing him customary procedures to which a freeman were entitled. Either way, the due process clause at most guarantees process. It does not, as the court's substantive due process case suppose, forbid the government from infringing certain rights, no matter what process is provided. This is correct. This is not a surprise that Justice Thomas writes this. He writes this literally all the time. He wrote this in the gun rights cases. He writes this every time. He does not believe in substantive due process at all. And on a pure legal level, he's correct. Right? This whole concept of substantive process, as he points out, is an oxymoron that lacks any basis in the Constitution. It sure does. It sure does. The resolution of this case is thus straightforward. Because the due process clause does not secure any substantive right, it does not secure abortion. Yeah, he doesn't believe in the concept of substantive due process at all. He doesn't believe in it. He never has. This is not a new opinion for Justice Thomas. He does not believe in the concept of substantive due process. Now, everyone completely freaks out at this point, or a lot of people freak out at this point because they want to freak out, because the entire Bill of Rights applicability to the states is through substantive due process, right? So the reason, like, all the Constitution applies to state level government, including like the Second Amendment and the First Amendment and all that, the reason all of it applies to the states is because of substantive due process. Okay? The Supreme Court said the reason that the states, like if Texas, cannot establish a religion or take away your guns or invade your home is because of substantive due process. Justice Thomas says, I don't believe in substantive due process. Therefore, they're like, well, geez, that means that he thinks that states can establish a church or invade your home or take away your guns. And no, he just doesn't think substantive due process is a thing. It doesn't mean that he doesn't think the states can do those things. He thinks that they can't do those things for other reasons. It's more pure. He's more legally pure, right? So he's like, yeah, this doesn't make any sense. It's not substantive due process. And like, okay, so then what is it? Well, for the most part, it's privileges or immunities, which again, as I pointed out, the Supreme Court nuked the privileges or immunities clause in slaughterhouse cases. That was perfectly good. It was sitting right there. It was going to be great and everything. And the Supreme Court said, nah, and then invented this entire idea of substantive due process that makes absolutely no sense. And then said all the rights apply through substantive due process. And Justice Thomas is like, well, this entire thing is kind of bullshit because it's not there, which it totally isn't. But it's like, but you can get there through other means, for the most part, which you totally can. So, in some sense, it's a bit of an academic exercise, because even though he's right, I mean, I doubt very seriously that you will ever find enough conservatives to be that hardcore, because that's some hardcore shit for what really amounts to not much in the end. You know, it's a very hardcore position, because it's like, why bother? It's like, because you're going to wind up exactly pretty much where you are probably anyway. So, like, it's not, the juice isn't worth the squeeze. It's not worth it to try to undo all this stuff and then just redo it. It's like, you know, okay, it's just like, can we all just pretend instead? Just like, let's all just pretend in our own minds that we strike out every time the word substantive due process clause appears in every decision of like the last 80 years, and we just pretend it says privileges or immunity, and we call it a day, right? Rather than actually go through the pain in the ass work of actually doing that for why, right? So it's a very legally pure position. So everyone freaks out. It's like we should question all these decisions. But yes, because Justice Thomas doesn't believe in it, and he's right. It's just like, he's not right enough for me to care about. I'll tell you what, even if I were on the Supreme Court, I'm like, no. I mean, you're right, Justice Thomas. It's just at this point, I can't be bothered to go through and fix all this shit, because what's the point? You know, for some reason. So, of course, you know, the court, of course, declines to disturb substantive due process because it's a pain in the ass, without much clear benefit. Cases like Griswold versus Connecticut, which grants the right of married persons to obtain contraception, Lawrence versus Texas, and Obergefell, are therefore not issue. Yeah. For that reason, we should reconsider all of our cases like Griswold, Lawrence, and Obergefell. We have the duty to correct this error. After overruling these erroneous decisions, the question would remain whether other constitutional provisions guarantee the myriad of rights. For example, we'd consider whether any of the rights that court substantive due process cases are privileges or immunities. They are. Almost certainly. So, like, why bother? To answer this question, we need to decide important antecedent questions of whether, including whether privileges and immunities protect any rights that are not established and enumerated by the Constitution, and if so, how to enumerate those rights. It's the same thing we've been doing in substantive process land. Sure, the privileges or immunities protects rights not mentioned. The Ninth Amendment told me that. How do we identify it? The same way, history, tradition. It's the same thing, just copy-paste. That said, even if the clause does protect enumerated rights, the courts conclusively demonstrates abortion is not one of them. Moreover, from being demonstrably incorrect, the legal fiction of the substitute process is particularly dangerous, and blah, 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 blah. So yeah, it's Justice Thomas just being legally pure. It's Justice Thomas being legally pure. He's correct, but you'll never find the votes. You'll never find the votes to do it, because why? It's just not worth it at this point. Even Justice Scalia basically gave up long ago, and you can read his decisions where he's giving up, and he even says basically he gives up in his decision. It's like, even he gave up. It's like, I can't do it. Let's just say it's fine. It's not, it's like, it's fine. Justice Thomas though is a purist, and he won't give up the fight, but no one's going to follow him because no one can be bothered, because it's like, what's the difference in the end? So it's, this opinion where Justice Thomas is writing this should not be a surprise to literally anyone, because Justice Thomas has written this opinion in basically every constitutional law decision on dealing with substantive process basically in his entire history. So it's only a surprise if you've basically never read a Justice Thomas opinion ever. So, yeah. So, yeah. So that brings us to the end of the discussion. Let's read some super chats we had along the way. And then Stephanie can bring to my question anything. Yeah. All right. So let's... Oh, wait. I need to go find my super chats. Where are they listed? Hold on. I know where they are. They're somewhere around here. Yeah. There we go. Let's see. Sean Walker gave 99 cents. Nimrith gave $5 to get me sing, which not tonight. NM says, question, but can wait till later. Does Dobbs allow a statute by Congress to federally legislate on abortion, or is it now barred as a state right? The question isn't whether it's a state right. The question is whether Congress has it as an enumerated power. In my view, the answer is no. Congress does not have the enumerated power. So I doubt that Congress has the ability to regulate this under interstate commerce, but they're going to try, and we'll see how that goes. Jackson says, is it possible criminal at some stages of unlawful? Could be like an ordinance, like fines for wrong signs. That's not directly a crime. Sure. I guess. Kiwi, New York Upstate says, people in 1602 also believed and killed women for being witches. So I don't think the reasoning about reproductive rights holds much water. Sure it does. Because that's how we base our Constitution on originalism. That's how we think. The Constitution, this is how originalists think. Yes, I think the thinking in 1602 bears a lot of significance on these questions. So, yeah. Peter said Barnes has posited the quickening was simply an evidentiary standard. As before the 19th Amendment, quickening would only be the only way to prove life. Thoughts on this legal theory? I mean, he might be right. The problem is that the evidentiary standard, as it were, doesn't change the legal conclusion, right? Because the Supreme Court has already told us that as to its decisions, the failure of the underlying reasoning does not change the legal conclusion. So Barnes is probably almost certainly right that quickening was used because it was the only way to determine, as a matter of factual reality, if there was a fetus or not to protect. It's just that factor no longer being true doesn't change the legal conclusion. The legal conclusion survives the factual underpinning. At least that's what the Supreme Court seems to suggest, or outright says. So, yes, that's probably the reason why quickening was chosen as a line, if it was, because it's the only way factually to determine it. It just doesn't hold that because we now can determine it through some other factual method, that the line doesn't continue to exist. The line exists despite the factual underpinning being eroded. Ashley King says, withholding and withdrawal of life support is legally justified. Isn't that legally the same thing as abortion, as the mother is the life support? No. The withholding and withdrawal of life support is provided by statute. There's nothing stopping a state from not doing that. There's no constitutional right. There's no constitutional right, it seems to me, to have life support withdrawn. Where would you find such a right? Except, I suppose you could find it in the idea of a person ability to refuse medical care. So I guess you could find it there. So if you're finding it, so in so much as, because a person has a right to refuse medical care, this is true. So even life-saving medical care, this is true. So if your reason for withdrawing life support is that the person making that decision is making it on behalf of the person who it's being done to, so it's really their decision, or this is at least the legal theory, then it's the person themselves making the decision for themselves. So even though they're unconscious, this is incidentally like why living wills are a good idea, because it helps to clarify these things. Otherwise, people have to make your decisions on your behalf, thinking what you would want. But I think the legal conceit for removing someone's life support is it's the person themselves making the decision. That's the idea. And that's just it's just someone who's speaking for them to make that decision. It's what they would have wanted. So it doesn't quite work. So I don't think the analysis quite works. Q squared seems like reasonable reasoning could be used to interpret support viability as being the analog of quickening. Maybe. Peter says, Kurt, doesn't 1868 matter because of the 14th Amendment? If the right is incorporated against the state, the date surely matters. It doesn't. Your thought isn't wrong. Well, it is wrong, but not for the reasons that. Okay, let me try this again. Your idea isn't wrong. It's just your conclusion is wrong. So yes, the 14th Amendment is adopted in 1868. So is 1868 the date matters? No, because the Supreme Court has made repeatedly clear that there's no difference between the right that's incorporated against the states and the underlying federal right. There had been an idea of that, like a dual track. Yeah, not the first time it had been suggested. It's been suggested, I think, every single time. It's been suggested, I think, every single time the Supreme Court has enacted or recognized a right, that the right that's adopted by the 14th Amendment isn't the same as the underlying right. So the date that would matter would be 1868, not 1791. The right as applied to the federal government would be 1791, but the right as applied to the states would be 1868. So the reasoning, the meaning of the First Amendment under this phrase, the meaning of the First Amendment under this idea would be different as applied to the states, because it's only made applicable to the states through the 14th Amendment. So the understanding of the First Amendment that would apply for federal law would be 1791. The meaning of the First Amendment that would apply to the states would be 1868. However, the Supreme Court has every single time it has ever come up refused this dual track thinking. Every single time. Every single time. So every single time they've said no. That is not correct. The meaning that the 14th Amendment adopts is the meaning that adopts in 1791. The meaning is the same as applies to the federal government and the states. So the correct date is not 1868. The only way that the correct date is 1868 is if you're engaged in this dual track thinking, which has been literally rejected every single time anyone's ever suggested it. So no. Lee Richards says, I was a 1973 hippie. In 1973, I'm rational now. But I'm not sure this is rational. Can we have rational law on this issue? It's rational. It just leaves a little bit to be desired in its reasoning. It is reasoning. It is rational because it's reasoned. It is a rational decision because it's a reasoned decision. It is rational. There are flaws in the reasoning, but that doesn't mean it's not rational. It just means there's flaws in the reasoning. That's okay, though, because we can correct those things and we still come to the same conclusion. So it is rational. It's just, not perfect, but that's okay. We can get there through other means. So it works out. NQS. Just got in here, but have you discussed how the Mann Act affects traveling to get abortions? It criminalizes crossings for immoral purposes. The Mann Act doesn't speak to this because the Mann Act is a criminal law, and like every criminal law, can only make criminal what was passed at the time. We don't do ex post facto. So whatever the Mann Act means, it can only mean what it meant when it was written. It can't possibly apply to abortions because that would make it retroactive, which is bullshit. So no. Beverly White says $1, Q squared gives $5. Quickening is 17 to 18 weeks. A woman would notice missing 2 to 3 periods. They might not. Women have not noticed less. Mary said the 2 houses and parties failed to address it and lazily bumped on the Supreme Court. Q squared said, do women rely on abortion being legal because there's a substantial chance their lives could be at risk from ectopic pregnancy or other threats? Again, no. You can't rely on something you can't rely on it because you're not relying on it. You can't rely on something you're not planning on. That doesn't make any sense. So no. Mary said, give it to the people. In this case, the women who want the choice. The women are able to vote just the same as anyone else. Susan said, here. Merger Men said, Kurt, what are your thoughts on the argument that the state bans infringes on religious freedom? The synagogue lawsuit in Florida, any merit? No, because it's religiously neutral. This is Smith, right? We've talked about this before, right? Can you regulate? You can have regulations and laws that are religiously neutral. As long as they're religiously neutral. You just can't treat religion worse. We've discussed this before. So the law is religiously neutral. So the synagogue lawsuit has no chance of working under the current case law. We are not treating the religion worse. We're treating it the same as everyone else. No abortion for anybody. It's a religious right of mine. Well, under Smith, that doesn't work. It's a general law of neutral applicability. So the synagogue lawsuit has no chance of working. Marine became a new member. Thank you for hitting the join button. Suzanne gave $4.99 with a jumping controller emoji. Q Square said, did you ever go to a slaughterhouse case and compare and contract rights and privileges versus substantive process? I'm interested in a rewatch. I've talked about slaughterhouse cases before. I don't think it matters. I think it would be the same. Superstitious Oblivious Bee became a member. Roasties on Self-Harm Watch. And Mary said, where in the Constitution does it force a specific person to provide life support for anything or anyone? It doesn't. The Constitution doesn't speak to it either way. The Constitution doesn't speak to it either way. Therefore, because it doesn't speak to it either way, it's therefore a decision left to the people and the legislatures therein. Can you explain why we're forced to wear seatbelts? Yes, because the legislature says so. That's why. The Constitution doesn't really speak to the issue of seatbelts. Therefore, it's an issue left to legislative judgment. The legislature said we have to wear seatbelts. Therefore, we have to wear seatbelts. Anything that's not committed to the Constitution is necessarily committed to the legislature. I hope this helps. All right. Any predictions on Chevron tomorrow? Is there a Chevron-based case coming down tomorrow that I'm not aware of? If there is, and we overrule Chevron, that will just be all my Christmases rolled up into one. If we overrule Chevron tomorrow, you will see a very unhappy Uncivil Law. It hasn't happened yet. If they're going to overrule Chevron, you will see a very, very unhappy. You'll be a very happy Uncivil Law. You'll know if they overrule Chevron. There will not be any question if they overrule Chevron. You'll know, I assure you. Stephanie says no. What am I saying no to? What are we saying no to? What did I do? What did I do? What did I do? Because I don't like Chevron? Chevron sucks. I've discussed it many, many times. I hate Chevron. I think it's a bullshit case. We've talked about this many times on the channel. Can't handle the Chevron? Who can't handle the Chevron? What wristwatch am I wearing? Oh, it's interesting because it's a wristwatch Stephanie gave me. Would you like to see it? Stephanie gave me this wristwatch. This one is an Invicta that she gave me. It's an Invicta chronograph. I like it. It's big and chunky. I can't handle it. She can't handle it. She doesn't want me talking about Chevron because she can't handle it. Basically, Chevron is the basis for the administrative state as we know it. It is the case that creates the administrative state in the federal government. Overruling Chevron would be a significant blow to the federal administrative state. Is what you need to know about that, but we don't need to discuss it in more detail. So yeah. Stephanie got me that watch. I can't handle you having a party over the end of Chevron. Well, that's unfortunate. That's unfortunate, Stephanie, because that's the thing that's happening. And while I do respect you as a channel manager, and I do respect you as my head mod and everything, yeah, you're gonna have to deal with the party for Chevron. We're gonna have hats and kazoos and noisemakers and champagne. It's gonna be freaking great. And if you can't handle it, I don't know what to tell you. I do love you, Stephanie, but I gotta kill the chevrons. We gotta have a party. You gotta have the party, and that's the thing that's happening. So there'll be much partying. But I'm sorry. What I meant to say, everyone, is there will totally not be a party of any kind relating to any overturning of Chevron. There will totally, absolutely not be a party. So make sure to let Stephanie know there will be no party. There will be no party. Rumors of the party were incorrect. I apologize for any misinformation relating to any potential parties. No parties. Yeah. Okay, we're going to end the stream, I think, for now. We're going to end the stream. We may be on to later with some playing of games or something, because that'll be fun. But this will bring us to the end of the stream, and this will be good. So I hope you've enjoyed this stream. How many of you are currently watching this, by the way? 936 of you are currently watching. I appreciate that you've been here for, what has this been? 2.5 hours as we try to dissect this case. And we'll just end with the too long didn't watch, I guess. The too long didn't watch is, this is going back to the states for their decisions. The federal government will probably try to pass some kind of legislation. I don't know about the legality of that, but we'll see about that. And Q squared is a... Okay. Q squared says, if a law was passed that banned unleavened bread, would matzah be allowed for any religious reason, or would Passover Seder just be SOL? I suppose the question would be, why are we banning unleavened bread? Do we have any rational basis for doing that? See, the thing is, at the bare minimum, we need rational basis to make laws. This, incidentally, for interesting, it's an interesting discussion, because I think it's for this reason that, for example, a decision like Obergefell would withstand. I don't like the way Obergefell is written. That's the decision that legalizes gay marriage, is Obergefell. I don't like the way Obergefell is written. I don't like it because Justice Kennedy, writes about liberty, and it's very fluffy and fuzzy, and You know, I don't really like the way it's written. It's yeah. But I think you get there under you get there from originalist principles, and you can just say because you can't meet rational basis. Like, okay, so one way you could solve this problem is by saying that gay people or whatever are a protected class. That the Constitution, there's no case that says that right now, and I'm not particularly inclined to create a protected class. So let's say, so one way to solve this problem is by saying that gay people are a protected class. But let's say I don't want to do that. Okay, so they're not a protected class. All right. So I want to I hypothetically want to allow for straight marriage but ban gay marriage. Okay. If I want to do that, I need to come up with some reason to do that, right? I need to come up with some reason to treat these two things differently. I need some sort of point of differentiation between the two to treat them differently, because equal protection requires me to treat the same things the same. Equal protection does not require me to treat different things the same. So all I need to do is find out a reason they're different. Any reason they're different will be fine. Any reason at all. The problem is, I can't come up with one. There isn't one. Nothing works. They all fall apart. Nothing works. It's like, okay, the reason I'm recognizing straight marriage and not gay marriage is because only straight people can have children. Okay. Hey, legislature, are you making any, it seems to me that that's not really your reason. I can't help noticing that you allow all the straight marriages. You allow straight marriages between people who are 90 years old. You allow straight marriages between people who are infertile. You allow marriages between people who have no intention of having children. You don't bother when you're handing out marriage licenses to check whether or not they're going to have children. You don't even bother asking. You don't even bother asking whether or not they're going to have children. It seems to me you're recognizing a lot of straight marriages that have nothing to do with having children. So, if not having children, that's not the reason you recognize straight marriages. You seem to recognize lots of them that have nothing to do with children whatsoever. Whether or not they can have children, whether or not they want to have children, it doesn't seem to be a factor. That's not your reason. Okay, well, you want to try something else? And basically every reason falls apart. You can't come up with one. Nothing works. You can't come up with a reason to differentiate the two categories. You can't come up with a reason. Be like, yes, this is the reason I'm allowing straight marriage and not gay marriage, because every reason when you examine it falls apart. And so the only reason that's left is just animus. I don't like the gay marriage. And that's not a reason. That's hatred. Hatred is not reasonable. I don't like the gay marriage because it's icky is not a reason. That is not reasonable. That's animus. Try harder. So the reason that gay marriage is legal is because you allow straight marriage and we have to have equal protection, and you can't come up with any rational basis to ban gay marriage. None of them work. They all fall apart. And so, yeah, you're there. Michelle says straight marriages have the potential to have children whether they plan to or not. Not all straight marriages do. No, Ms. Michelle, I hate to break it to you, but not really. Last time I checked, 2 90-year-olds can get married, unless I missed a memo. I mean, did I miss a memo about the 2 90-year-olds not being able to get married? I don't. All straight. Some people are just infertile. Did I miss a memo about the infertile people not being able to get married? Did I miss a memo about that? I don't remember that one, so it doesn't quite work. Yeah, that's not the reason. Because I'm prevented from asking medical questions as the state. Why? Why am I prohibited from asking medical questions as the state? Why can't I do that? Why not? Why can't I ask? Why can't I? In fact, I know for a fact I'm not prohibited from asking medical questions. Some states require blood tests before getting married. Are you not aware of that? Are you not aware that some states require blood tests before getting married? I'm not prohibited from asking medical questions. Who told you that? I'm certainly not prohibited from asking their age and whether or not they're 90 years old. Who told you I wasn't permitted to ask medical questions? HIPAA's not going to stop me. HIPAA's not going to stop me. That's not a problem. Yeah, HIPAA's not a problem. Why is any marriage a government matter? Well, there's nothing prohibiting it from being. I mean, you don't have to get married by the state. Nothing's requiring you to. If you don't want to have a marriage that's recognized by the state, that's not a problem. You don't have to. You don't have to have a marriage recognized by the state if you don't want to. If you want to deal with it as purely a religious affair, go crazy. That's fine. So yeah, basically nothing works. And also, for that matter, interracial marriage. First of all, race is a protected class because of the 13th Amendment. But even if it weren't a protected class, I'm going to allow two white people to get married, but not a black and white person. Why am I doing that? What is my reason? Can you come up with a reason? Any reason at all that makes any sense? Nope. You can't. No, nothing makes any sense. You can't even make a rational basis. Every reason falls apart upon examination. You can't come up with any reason that makes any sense. There's such a thing as common law marriage in a couple states there are. Don't live in one of those states, you'll be fine. What's the reason for banning abortion? We want to protect potential life. I mean, that's a reason. That works. We believe that that's a potential life, and we believe that's worthy of protection. I mean, it's any reason. Is it reasonable to believe that it's a potential life? Yeah. Is it reasonable to want to protect it? Yeah. I mean, any reason is a pretty low standard. I just can't come up with one for gay marriage that makes any sense. Not really, because potential's not actual. Did I say it was actual? I don't recall saying it was. I said it was potential. We want to protect the potential life. How's that not reasonable? I believe it is a potential life. I want to protect the potential life and allow it to grow without interference. That's a reason. That works. Blood tests aren't required by any state anymore except in New York if you're black or Latino. Well, even if that's true, they could be right. They could be done. There's nothing that stops the state from doing them. So even if you're correct that no state requires them, there's nothing stopping a state from requiring them. They could require them again if they want to. Would an abortion Federally prohibit you from owning a firearm since it's a state felony? Perhaps. Yes. Then prenatal care should be mandatory? No, that doesn't flow. I believe it's a potential life, and therefore I want to prevent abortion and allow it to thrive or not on its own merits. I mean, me providing prenatal care would be interfering with nature. I just want to allow nature to do its own thing. I think it's best we have a non-interference directive when it comes to the potential life. You know, the potential life is existing, and I just think it's best that we have a non-interference directive, allow it to thrive or not, as nature may dictate. I mean, again, rational basis is pretty low. I don't have to come up with much. You know. Yeah. Someone asked, what's a good argument against abortion? I mean, again, the Supreme Court just told me it's rational basis. Any reason will do. Any reason will do. Any theoretical reason will do. It's a potential life. If it continues to thrive on its own merits, it will be born and become a human being, and it's worthy of protection, and I don't think we should have to provide care for it, because that would be interfering with nature, and I think we should allow nature to take its course. Okay, that, again, it's not much of a reason, but I don't need much of one. Rational basis is pretty low. Rational basis is a pretty low bar. Anything will do. What if a woman decides to go on a hunger strike? That's improper. When I said we wanted to allow nature to take its course, I meant through a medical intervention. We want you to continue eating, because that would be unnatural for you to stop eating, because eating is part of the human condition. So eating is a natural thing to do. So us requiring you to eat so that you don't starve your baby to death is proper, because that's part of the natural order. Again, I'm not... Yeah, let's wrap this one up. Okay, let's wrap it up. Stephanie's right. All right, so I think we've got the point through. Let's... Law Patrol says letting nature take its course. So where do you fall in the use of baby formula? Oh, well, once it's I mean, you do understand, Law Patrol, that, once it's born, we're in an entirely different universe, right? Because once it's born, I'm not even talking about abortion anymore. Now I'm talking about a completely different thing. Now it's like, okay, once it's born, it's like, there's an affirmative duty to provide to your children. That's long been recognized by law. So you have an affirmative duty to provide them the things that they need to, I don't need to continue justifying this thing. It's fine. We get the idea. And I'm going to wrap this up. And if you've been enjoying this thing, please remember to like, comment, subscribe if you enjoyed this analysis. It's only through your continued support that this can be possible. I've been Uncivil Law. Until later, my friends, I hope all's well. Cheers and goodbye.